side 47, but causes which are of such a kind that there can be no doubt of the law relative to them do not usually come to be tried at all. Does anyone claim an inheritance under a will which the father of a family made before he had a son born? Nobody, because it is clear that by the birth of a son, the will is cancelled. Upon such points of law, therefore, there are no questions to be tried. The orator, accordingly, may be ignorant of all this part of the law relative to controversies, which is, without doubt, the far greater part. But on those points which are disputed, even among the most skillful lawyers, it will not be difficult for the orator to find some writer of authority on that side, whichsoever it be, that he is to defend, from whom, when he has received his javelins ready for throwing, he will hurl them with the arm and strength of an orator. Unless we are to suppose, indeed, I would wish to make the observation, without offending this excellent man Scaevola, that you, Crassus, defended the cause of Minus Curius out of the writings and rules of your father-in-law. Did you not, on the contrary, undertake the defense of equity, the support of wills, and the intention of the dead? Indeed, in my opinion, for I was frequently present and heard you, you won the far greater number of votes by your wit, humor, and happy raillery, when you joked upon the extraordinary acuteness and expressed admiration of the genius of Scaevola, who had discovered that a man must be born before he can die, and when you adduced many cases, both from the laws and decrees of the Senate, as well as from common life and intercourse, not only acutely, but facetiously and sarcastically, in which, if we attended to the letter and not the spirit, nothing would result. The trial, therefore, was attended with abundance of mirth and pleasantry, but of what service your knowledge of the civil law was to you upon it, I do not understand. Your great power in speaking, united with the utmost humor and grace, certainly was a great service. Even Mucius himself, the defender of the father's right, who fought, as it were, for his own patrimony, what argument did he advance in the cause when he spoke against you that appeared to be drawn from the civil law? What particular law did he recite? What did he explain in his speech that was unintelligible to the unlearned? The whole of his oration was employed upon one point, that is, in maintaining that what was written ought to be valid. But every boy is exercised on such subjects by his master, when he is instructed to support in such cases as these, sometimes the written letters, sometimes equity. In that cause of the soldier, I presume, if you had defended either him or the heir, you would have had recourse to the cases of Hostilius, and not to your own power and talent as an orator. Nay, rather, if you had defended the will, you would have argued in such a manner that the entire validity of all wills whatsoever would have seemed to depend upon the single trial. Or if you had pleaded the cause of the soldier, you would have raised his father with your usual eloquence from the dead. You would have placed him before the eyes of the audience. He would have embraced his son, and with tears have recommended him to the centrivary. You would have forced the very stones to weep and lament, so that all that clause, as the tongue had declared, would seem not to have been written in the 12 tables, which you prefer to all libraries, but in some mere formula of a teacher. 48. As to the indolence of which you accuse your youth for not learning that science, because in the first place is very easy. How easy it is, let them consider who strut about before us, presuming on their knowledge of the science as if it were extremely difficult. And do you yourself also consider that point, who say that it is an easy science, which you admit as yet to be no science at all, but say that if somebody shall ever learn some other science, so as to be able to make this a science, it will then be a science. And because, in the next place, it is full of pleasure. But as to that matter, everyone is willing to leave the pleasure to yourself and is content to be without it. For there is not one of the young men who would not rather, if he must get anything by heart, learn the Teucer of Pacuvius than the Manilaean laws on emption and vendition. And in the third place, because you think that from love to our country, we ought to acquire a knowledge of the practices of our ancestors. Do you not perceive that the old laws are either grown out of date from their very antiquity or set aside by such as are new? As to your opinion that men are rendered good by learning the civil law, because by laws rewards are appointed for virtue and punishment for vice, I, for my part, imagine that virtue was instilled into mankind, if it can be instilled by any means, by instruction and persuasion, not by menaces and force and terror. As to the maxim that we should avoid evil, we can't understand how good a thing it is to do so without a knowledge of the law. And as to myself, to whom alone you allow the power of managing causes satisfactorily without any knowledge of law, I make you, Crassius, this answer, that I never learned the civil law, nor was ever at a loss for the want of knowledge in it in those causes which I was able to defend in the courts. It is one thing to be a master in any pursuit or art, and another to be neither stupid nor ignorant in common life and the ordinary customs of mankind. May not every one of us go over our farms or inspect our country affairs for the sake of profit or delight at least? No man lives without using his eyes and understanding so far as to be entirely ignorant what sowing and reaping is, or what pruning vines and other trees means, or at what season of the year and in what manner those things are done. If therefore any one of us has to look at his grounds or give any directions about agriculture to his steward or any orders to his bailiff, must we study the books of Mago the Carthaginian, or may we be content with our ordinary knowledge? Why then, with regard to the civil law, may we not also, especially as we are worn out in causes of public business and in the forum, be sufficiently instructed to such a degree at least as not to appear foreigners and strangers in our own country, or in any cause a little more obscure than ordinary should be brought to us, it would presume to be difficult to communicate with our friend Scavolia here, although indeed the parties whose concern it is bring nothing to us that has not been thoroughly considered and investigated. If there is a question about the nature of a thing itself under consideration, if about boundaries, as we do not go in person to view the property itself, if about writings and bonds, we of necessity have to study matters that are intricate and often difficult, and if we have to consider laws or the opinions of men skilled in law, need we fear that we shall not be able to understand them if we have not studied the civil law from our youth?